and I would like to talk about the new basic law, the new constitution for the Internet, the Digital Services Act. And we as Europe are the first democratic continent to set rules for all platforms, all digital platforms, but in particular the very large online platforms. So that is a big step, and I would like to give you a brief introduction, which really takes you through the main aspects of this law, so it isn't so abstract anymore. Here's my presentation. So the breakthrough happened in the night from Friday to Saturday, which also meant that German reporting, well, was a bit slow, let's say, because journalists weren't quite present on Saturday, and of course there were other European events happening throughout the weekend, the elections in France, so you might not have heard that much about the Services Act yet, but I'll give you the details.
Jetzt bewegt sich meine Präsentation. Jetzt so geht's. Genau. Also, was war eigentlich die Ausgangslage?
So, what was the original situation? The Commission tabled the first suggestion for this law, the first draft, in September 2020. But of course, that is something that everyone had been working on for a long time. And the goal that had always been stated was to promote digital economy in Europe and to make sure that large platforms would also establish themselves in Europe and would have a positive framework. And then national authorities and also civil societies voiced their concerns and said, well, we have to implement our existing legislation at first. If we have illegal content, for example, in one country, if there are orders from a German country to work against that, then that has to be enforced. But on the other hand, the users always said that their right to freedom of opinion, freedom of speech in the internet cannot be cut or deleted arbitrarily by these platforms. So that was a very important concern as well. And so while we were working on the DSA, we also realized that the fight against disinformation and the fight against hate speech was another major aspect. So in general, negative influence of social networks, social media, is something that we wanted to focus on as well, because they do have an impact on political decision-making or creating of political opinions. And that is why we didn't only want to focus on content, but also on the platforms in general. How about the scope of this legislation? Of course, a lot of these platforms are established in the US. TikTok is established in China. So how about our possibilities to enforce this legislation? Well, in terms of the DSA, we focus on the recipients or users of services which are happening, which are offered in the EU, irrespective of the place of establishment of the provider or the platform. Liability was also a very important issue. Intermediary platforms, for example, can they be made liable for contents which are posted on their platform, which are tweeted via their platform? That is also not the case in the e-commerce regulation and is still the case here. So for non-user generated content, these platforms cannot be made liable as long as they are not aware of these contents. And there is also the ban on a general monitoring. Now, one very important point, which I already alluded to before, orders to act against illegal content or orders to provide information from authorities in the member states have to be enforced and have to be enforced or implemented by the platforms. There are very clear rules on how to deal with illegal content now, which have to be followed by these platforms. So as the Greens, of course, we support this. And we wanted to implement this for judicial authorities, not just for civil authorities, because we have to make sure that the police, for example, can get active against some providers. But that is the compromise that we are looking at now, and I think it's quite a broad compromise, so it is okay for us. It does mean, however, that court decisions of German courts will have to be revoked. So we'll have to see how that goes regarding Twitter, for example. Then points of contacts, legal representatives. There has to be a point of contact, a central point of contact declared by the platforms or the providers of services to be able to communicate directly with the authorities, but also with the users, with the recipients of the services. And that also applies to service providers who don't have an official establishment in the EU. They still have to have a legal representative, a legal entity here in the EU, which is a contact point. So we won't have a case as we have with Telegram, where we have a lot of illegal content, but as a domestic authority, we didn't even have a contact person or a contact point. That situation will no longer exist or will be made impossible by the law. Now, terms and conditions and transparency. So terms and conditions and general standards when it comes to moderating contents have to be objective. Also, when it comes to non-illegal contents, even if they are undesirable content. So these kind of moderation rules have to be objective, have to be applied non-arbitrarily, and that means such a case as was sometimes the case with Facebook. Francis Hogan told us that prominent users or well-known users could basically do whatever they wanted. Their people were moderated by real people, especially when it came, or even when it came to illegal content, but normal users who didn't have this kind of special VIP status were just subjected to arbitrarily applied upload filters. And that can no longer be happening. We have to have uniform standards. That is what this new regulation says, and they have to be applied by all platforms. Of course, basic law or basic rights have to be taken into account as well, and a machine-readable transparency reporting has to be made available once a year as well. Very large platforms also have to disclose how much staff they have. I'm sorry, there's a lot of noise in the background, says Alexandra, but I hope you can all understand me. So these very large platforms have to disclose how much staff they have and how they train this staff and support the staff when it comes to moderating functions. And there is an interesting phenomenon with regards to that. In Germany, we have a lot of staff usually who work for platforms and do the moderation because, of course, we have a very strong civil society in that regard. They monitor very closely what's happening there. But in other countries, that is not so much the case. Like in Eastern Europe, for example, disinformation is not really a big issue in the minds of people, and there is not a lot of moderation either. Now, we have a vaccination rate of only 28% in Eastern European countries, so we might wonder whether those two are linked. But anyway, I'll leave that up to you to decide. But that is what we negotiated, and that will be the rule now. And what I just said, so enforcement of national orders against illegal content, but also terms and conditions which cannot be used arbitrarily anymore. Those are aspects which are very relevant for the debate that we've listened to or read about today. Takeover of Twitter by Elon Musk, who said he's only buying Twitter because he doesn't want moderation anymore. Absolute freedom of speech is what he calls it. Everyone is allowed to say anything they want. And those rules, however, the rules that I just described to you will apply to Twitter as well. So in Europe, he will not be able to do what he said today. Now, notification procedures. Harmonized notification procedures to notify potentially illegal contents. That is basically a very important point which we already have in German legislation, and that will become European legislation in a different way, in a different shape, but still the idea is the same. Very clear rules on notifying potentially illegal content. And there might also be more rights for recipients and users of services by using these notification procedures. It is also obligatory now to make sure that there is a complaints procedure in place that users can use, and another obligation to have out-of-court dispute settlement procedures to make sure that users, that recipients of services have the possibility to complain, to do something against something where they were mistreated without having to go to court. Next point, online marketplaces. There are, of course, very dangerous products available online, which you wouldn't be able to find in a European shop because they are simply dangerous. And now there are rules for these online marketplaces. One important aspect is traceability. So products have to be registered to make them traceable, and databases have to be used for random samples to test this traceability. That is something that doesn't really go as far as we would have wanted. We would have wanted the same level of consumer protection online that we already have offline, but there was a lot of resistance from the European Council, from the different member states there. The next area also is important when it comes to systemic questions. I've already talked about different types of content that we have to deal with, but there are also questions such as what do the platforms do to create all this kind of problematic content? What is there a contribution by them? What role do they play? And we've heard what Frances Hogan told us as a whistleblower. We know that there are negative consequences. For example, very polarizing contents will be further distributed by algorithms and will further create a heated debate and propaganda speech, etc. So now the platforms have to explain how their recommendation system work. Users have to have the possibility to understand why they are seeing a certain type of content. So transparency is very important. And very large platforms also have to create an option to be able to see those contents which are not personalized, which are based on profiles. We also wanted to have a chronological option here. Unfortunately, we didn't get a majority for that, but at least we got this point. Now, manipulative practices, dark patterns, that is the kind of technical term here, which basically means that users are confronted with being pressured into decisions. A typical example would be the cookie banners. So you have to decide whether you give consent or not to cookies, especially when it comes to data processing. And we all know that it's always very easy to give consent for everything. However, it is very difficult to refuse your consent. You don't usually have an easy link that you can click on the first banner, on the first page. You have to really search for it, go to the next page, and some really hide it, so you can't even find it. And that is something that is no longer acceptable to us, and that we want to tackle with this new law. Then again, you are constantly bothered if you've refused your consent. You will constantly be asked again and again and again, and it's often difficult to unsubscribe or close an account, etc. And we, as the Parliament, thought this is a very important aspect, because if you are not forced into giving your consent, you can also make sure that not that much data is collected. With Apple, for example, you sometimes have the possibility to say yes or no when it comes to data processing, and globally, about 80% of people say no, they don't want this kind of data collection. However, many people simply say yes because they cannot find the no option. It's just too difficult, and that is something that we want to change. The solution which was found via this new act, is a bit tricky because we said, yeah, we have to have a clear option to not give consent. However, the practices that we stated as problematic in our Parliament's report have not been, well, copied, so to speak, into the law. And we have a certain article, a second article, which says that existing consumer protection laws or activities which are covering by existing laws would now not fall under these new rules. So there might be some exemptions. That is unfortunate, but is unfortunately not the case, and we don't have as much legal security anymore.
Right, another very big and important topic is surveillance advertisement. And this is something we really fought for, and other members of the Greens. Online advertising is one of the financial foundations of today's internet. But today's business model operates on the principle of surveillance capitalism, meaning creating comprehensive data profiles on individuals that enable manipulation and control of entire populations. This I really have to explain was one of the main targets that we wanted um, to achieve in this in the Digital Service Act. Well, the deal, let's say, what was its outcome? It's sort of medium lukewarm. We have achieved a prohibition of advertising based on profiling, which relies on sensitive data. So that would be political and sexual orientation, trade union membership, or religion. Now, at a first glance, this might sound great. However, in legal terms, it's not very clear, and it actually is a far cry from what the parliament had demanded. What we asked for, what we demanded was that any kind of targeting based on desensitive data would be prohibited. And this very complicated and complex phrasing, the terms chosen, is a compromise that goes in the right direction, but it's not quite clear what the specific impact is on those who run these platforms. What we did achieve was a prohibition of profiling based advertising that uses personal data of minors. However, here the challenge is it's really hard to say who are those minors without allowing the platforms to collect more data and create more profiles. So the glass is half full, half empty, if you like, because we didn't get everything we wanted to achieve it. However, it's also half full because we have managed to explain that this kind of advertising, that this kind of profiling is harmful. And yeah, we didn't achieve a total ban, but I think we're about to we've closed the door, but we still need to turn the key, if you like. Now, I think we're going to see more in the future. Now, the rules for the big ones, the VLOPs, this is a very exciting part of the DSA because we do not find any other legal act where this is provided and stipulated. So here we're looking at the systemic risks produced not by the users but by the platforms. Here it was recognized that there is a risk for democratic societies. The solution is rather complex, but also rather elegant, starting with risk assessment and mitigation that the very large platforms need to carry out every year. That is to say, they have to answer to the questions in what way their design and the algorithms influence the provision of discrimination, what is the impact on consumer protection, on the basic laws, but also anything dealing with violence, gender-specific violence, or mental health of the users. Those are just a few examples. And here you see that a number of very specific issues are taken up that we're dealing with. For example, Russian disinformation on COVID, or the question why young girls are driven into anorexia. This is what you can put under this category in their, the VLOPs must now conduct this annual assessment of risks. However, these risk assessments at the same time are the legal basis for independent research. And that's where it gets really interesting. They might be employed by civil societies, organization, and this is a great success achieved by the Greens, because all these very large realms weren't even covered at the beginning. So researchers, not just working for research institutes or universities, but also working for organizations and civil society, and they've done excellent work over the past years, can verify, can evaluate this risk assessment, and they can be granted access to the data of these very large platforms to make sure whether data privacy rules are adhered to. So in the future, we will see major research projects also to prove the impact, the influence that these platforms take on society, on democracy. What else? There is a new article that the Commission has brought in the very last minute, so to say. This is crisis management in very exceptional situations, like now with Ukraine. Many of you, I'm sure, will have heard that RT, Russia Today, and Sputnik Day have been prohibited, not just the TV stations, but their content, all of our content on the internet. So this is a very serious violation, and disallowed for sanctions, of course, the basis for sanctions from abroad. And of course, it made us see that for these situations, it might need a different legal act to be able to take action. So the EU Commission, on recommendation of the DSA panel consisting of the 27 member states, can require VLOPs to take action, to carry out specific risk analysis, for example, or take other measures not specifically outlined in the existing text. However, this crisis situation must be limited crisis response must be limited in time, maximum 3 months. I think here in legal terms, in terms of the rule of law, we can do a little better. There's still room for maneuver, but what's important is that we have a very clear and transparent public procedure. So this is something very positive. The Commission's decision must be made public, as I explained. So access to platform data, coordinators, so somebody who would be responsible for the all over platforms, and there's a European body, European Panel on Digital Services representing the national bodies, and the Commission is responsible for direct supervision and enforcement for VLOPs and advisors on cross-border cases. This is very important because what we need is to be able to act against these very large platforms. At the same time, with smaller platforms, we have to make sure that distance isn't too large and that we need to understand the national context. This is where the member states play in. Now, what kind of sanctions do we have on enforcement? Payments up to 6% of global turnover, penalties or periodic penalties of up to 5% may be imposed for persistent violators until the non-compliance is done away with. So interim measures, for example, may be ordered to be put an end to the violation, or in special situations, the service may even be suspended altogether if somebody's life is threatened, for example. And this is very much up to date. Elon Musk, for example, buying Twitter as a hobby, if you like, and these penalties are something he can pay with his pocket money. So yes, it's a long way to go still, but other possibilities exist to sanction platforms and people. And what's interested is that VLOPs now share the financial burden of their own supervision via fees. So they need to pay a certain share for the costs incurred because other bodies need to monitor them. So it's comparable to banks, really. So this was an amendment by the Greens, the Commission. It wasn't accepted in Parliament, but the Commission and the Council have taken it up again. Max is getting a little nervous. So what are my conclusions? I think that we have seen a breakthrough in Europe. The day before Hillary Clinton and Barack Obama have tweeted it. So there is worldwide attention, even from the United States, on what's happening here. I think the US is a very good example here, because there's no liability for the opinion represented on the platforms, but the platforms are made responsible for their actions. And here we've seen a shift in things, and debate, section 230, this has been filled with life now, because it's the question is, what are the platforms doing? What are they responsible for? So the systemic risk is important here, and the ranking based on the criteria that we see today, these are recognized and they're addressed. However, we still see limits, the prohibition on profiling for advertising, and the modification of recommendation system. This doesn't go far enough. The same goes for dark patterns. The profiling for recommendation systems has not been addressed, and the systematic risks are we see research done into that, but we don't see a total ban. So we would need more information, more intelligence to see how the proliferation can be modified, and what are the mechanisms that we can use to stop this without cutting down on people's freedom of opinion. But things are moving, it's an avalanche, and we see changes from day to day. So we have the instruments, but it'll take some time to make good use of them.